Okay, hello everyone. I'm so sorry. This is Ann Badmus, and welcome to our webinar. Unfortunately, we had technical difficulties. The platform crashed on us. So if you hung in there and you're still with us, thank you so much. I apologize again for the system crashing. Please let me know if you can hear me by typing yes into the pane. Okay, into that. Okay, great. Again, I am so sorry about this technical problem and we're running so late behind, but we're going to do our best to give you the information that you came for and try to present this information as quickly as possible. As well, because I know everybody has some time constraints as well. So again, welcome to our webinar. I'm Ann Massey Badmus, and we're today going to talk about alternatives to H-1B visas. As you can see on the screen, we have some options here in terms of asking questions. So you can ask questions at any time by using your Q&A section. I believe it's on the right of your screen, or if you're facing your screen, it should be to your right. So there's a chat section, and then there's a place that looks like a question mark, and you can do questions where it says question mark. So go to the Q&A panel and type your questions there rather than in the chat. That's the way that we're going to be able to better handle your questions by using the Q&A pane as opposed to chat. So, and also regarding questions for confidentiality, please ask your questions in a general manner and with no personal details. This is an open forum and we want to make sure that we respect the confidentiality of your case in particular. If you're asking questions that relate to you, again, try not to include personal details, but just ask questions as generally as possible. And if our answers require more information, then we would ask you to schedule a time to speak with one of our attorneys. Just a little bit about our firm. This is Badmus Associates. For those of you who aren't familiar with us, we've helped and worked with thousands of clients, immigration clients since 1993, and have received some recognitions as best lawyers in the Dallas magazine, our Dallas D magazine, and we've also been selected to Best Lawyers List and Best Law Firms in the U.S. for immigration. Also, I just so you understand that the content in this presentation is for informational purposes. So we are unable to give specific legal advice for your circumstances. The information here is very general. It gives you some idea of your options, but for your specific case, please be sure to contact either one of our immigration attorneys or another qualified professional. So today we're going to go over, again, some of the options for work visas or permanent status as well. And so our agenda is going to cover, first of all, H-1B visa. So our presentation is entitled Alternative Work Visa Options, and the alternative is just really alternatives to the typical H-1B professional visa that most professionals use. So I'm just going to talk briefly about that just to give you a basic understanding of what an H-1B visa is. And then we'll talk about other options, alternative options rather than H-1B visa. So starting out, as I mentioned, with the H-1B visa overview, just want to give you brief details about that. So an H-1B non-immigrant visa is a temporary visa that allows a non-citizen to apply for work authorization in what's called a specialty occupation. So someone who qualifies as working in a specialty occupation, which would typically is an occupation that requires at least a bachelor's degree or higher, and it is allowed that the H-1B visa, if you qualify, can be issued for specific employment with a specific employer who is considered the petitioner, and you can receive an H-1B visa for up to 6 years, sometimes longer, depending on whether you apply for permanent status during that time frame. So what is a specialty occupation? So as I mentioned before, the occupation must be something that's considered highly skilled, requiring specialized knowledge, and also requires at least a bachelor's degree as necessary in order to actually fulfill that occupation. So Typical types of specialty occupations are physicians, lawyers, teachers, architects, but so many more, such as computer science or IT professionals, marketing professionals. Any position that can be proven to require a specific degree in order to qualify can qualify for an H-1B visa. So the employee, if you are an H-1B employee, then, or potential employee, you need to show that you have at least a bachelor's degree or higher. Or if you don't have a bachelor's degree but have at least 12 years or more of experience, you can also qualify for H-1B visa. And if your specific occupation requires that you have a license in order to practice that profession. So, for example, a physician has to have a license, CPAs have to have a license, lawyers have to have a license. So if you're one of those types of occupations, then you need to actually have the full license to practice in that state before you can qualify for an H-1B visa. But why we're here today mainly is to discuss other options than H-1B is because most H-1B applicants or potential applicants have to go through the H-1B numerical limitations, so what's called the H-1B cap. So for the H-1B visa, if you are a new H-1B worker, or in some cases, if you were an H-1B worker that was exempt from these numerical limitations, which we'll talk about a little bit later, then you are subject to this quota. And the quota is basically requiring that the quota basically is 65,000 for new H-1B visas and 20,000 additional visas for people who hold U.S. master's degree or higher. But the problem is that it applies to, as I mentioned, first-time H-1B workers or previous CAP H-1B workers. And in some cases, there will be other H-1B workers that would be subject to the cap. So common reasons why people want to look for other reasons or other ways to get work authorization or to get a work visa is because the CAP application is not selected. So if you do try, if you're planning this year to apply for the H-1B cap lottery, you may you have to understand that the chances of winning one of those slots is probably about 20% because, and that's no mathematical calculation on my part, it's just a guesstimate, but let's say 20%. A chance of actually being able to capture or win one of those H-1B cap visas. And that's because the government, or most people apply, many people apply. And for example, last year we had over, I think, nearly 400,000 applications for that 85,000 lottery, 85,000 H-1B visa lottery. So that's one reason why people who actually probably did not win the H-1B cap lottery would want to look at other options. Or if you are past the deadline for even trying to get an H-1B cap visa, then, if you're too late to apply, then that might be another reason, because currently the time to apply for the H-1B cap or to register for that lottery is usually from March 1st to March 20th or so. And if you are starting to look at this after that date, then certainly you would not be eligible for the H-1B cap even to try for that. Sometimes people look for other options because even you were on an H-1B, but your maximum 6 years have been reached and you still want to remain in the U.S. And you may, so you have to look at other options to extend that legal time to be legally in the U.S. and continue working. Another reason is because your H-1B visa application was denied. Sometimes H-1B visas applications do get denied. It could be it will be for specific reasons. Typical reason would be that the government determined that the occupation was not a specialty occupation. That's the usual typical reason for denial. So those are the basic reasons for applying or looking at other options for an H-1B visa. Another So let's look at those alternatives to H-1B visas. Let me just see here. Okay. So one of the ways that people can consider applying for H-1B, looking at another type of visa. Let's say that you have actually, as I mentioned, completed all 6 years of the H-1B cap, of the H-1B visa, so you don't have much time left. But you did leave the United States at some point, and so you did leave for the 1-year period that's required for you to be able to be considered for the H-1B cap. Or, I'm sorry, let me backtrack. So basically this means that what I'm saying here is that if you had an H-1B visa, you were counted in the cap before, but let's say you only completed 3 years out of the 6-year maximum, and you now want to, and you left the United States and you want to come back, or you went to a different status and you want to go back into H-1B status, then in that case, you can still apply for the remaining time that you were outside the for remaining time on that 6-year period, and you can apply at any time. So you're not concerned with the H-1B cap. So this is a situation where people did not, where someone who was an H-1B did not fully use their H-1B time and then had a gap between their H-1B visa expiration, and now are looking back to come back and continue working in the US. So that's one option. Another option to look at is cap exemption. Now, this is going to be only for specific people who can qualify or who can get employment with one of these cap exempt types of H-1B visas. So again, we're still talking about H-1B visas, although, we're going to talk about other options as well. But if you are eligible for what's called a H-1B cap exempt visa, then you will no longer be concerned about competing against all of the other people who are trying to get an H-1B visa out of that limited pool of visas. So in this case, a cap exempt employment is basically there are 3 types of cap exempt employers. You have the universities and nonprofit organizations that are associated with universities. So if you have an employer who is a university, you don't have to worry about the cap. They can apply at any time if they're a qualifying university. If you have an employer who is not a university, but they work closely with the university, for example, they have internships that they provide to a local university. They may do other kinds of services that are related, or teaching services that are related to university purposes. So if they're a nonprofit organization that can do those things, that has that kind of affiliation, then that would be a cap exempt employer, and you would not need to worry about competing for the H-1B cap. Other cap exempt employers are the government research organizations and nonprofit organizations, again, that are affiliated with government research organizations. So if you're going to work at that type of organization, you're not subject to the cap. And the last area for cap exempt employer, which is more common for those who are involved with or who do qualify, is the for-profit employment, for-profit employers, but you will actually work at a nonprofit university affiliated facility. So for example, if you are a physician and you're going to work for a for-profit physician hospitalist group, but they're going to have you work at a hospital that is either a university hospital or it's a nonprofit hospital that has a teaching program. If you're going to work at that type of facility for more than 50% of your time, then you can be cap exempt as well and not have to compete for the H-1B cap visas, even though your employer is not a university or is not a nonprofit. They are for-profit, but you are going to be working at a qualifying nonprofit institution. And so that's what we call third-party cap exemption. So those are the options for not having to go through the H-1B cap and getting an H-1B visa any time of the year, and again, without consideration of the cap. Then we have other cap exempt beneficiaries. These are specifically physicians who have agreed to work in an underserved area. So those individuals can, if they are approved for working in underserved areas, then they can get an H-1B visa regardless of the type of employer. I mean, regardless of whether the employer is a university or CAP exempt. The physician themselves are always CAP exempt, and they do not have to worry about the CAP. So another option for people who did not get counted in the CAP and you think that the only option you have is an H-1B, you can also consider what's called a concurrent H-1B option. Now, this is more of the situation where you still have to have a CAP exempt employer, but let's say you also want to work for an employer who is not CAP exempt. So what we do in some cases, or what we suggest in some cases, if it's feasible, is that if you are a CAP exempt H-1B, you're working for a CAP exempt employer, but you want to either start your own organization and be an H-1B worker for your own company, or if you have a private employer that wants you to work part-time for them or even full-time for them, then you can go with the concurrent H-1B option. And the way that works is that basically the for-profit organization offers you part-time employment, which can be part-time, can range anywhere from 5 to 60 hours a week. That's typically a full-time employment, but basically the application is for part-time employment. And then your start date of the H-1B must be a date before your current before your CAP exempt employment ends. And also your concurrent H-1B application must be filed and approved before your current CAP exempt employment ends. So it's a little complicated structure, and it's something that if you think it's a possibility, if you're a CAP exempt employee and you want to work for another employer that is not CAP exempt, definitely reach out to us so we can explain more in detail exactly how that would work in your specific circumstance. Another option for people who are not able to get into, or who aren't able to get one of the CAP visas, is an F1 student. So if you are an F1 student already and you have the OPT and you're in the STEM, you're in one of the STEM fields, science, technology, engineering, or math fields, then of course you can extend your OPT for at least 24 months. So in addition to the 12 months of OPT, you get another 24 months for a total of 36 months of OPT. So that's one option for those. But the requirement for any of this option is that the employer has to have E-Verify as part of their hiring or their HR practice and hiring people. So again, a little more complicated, but it's just one option to look at for these students who are F1 students who have qualified or can qualify for the full 36 months. So you definitely want to do that. All right, so next, we're now going to talk about, aside from H-1B, or a little bit aside from H-1B, we're going to talk about some country-specific temporary visa options. So this country-specific meaning that you have to be a citizen of a specific country or countries to qualify for this type. So we're going to talk a little bit about the H-1B1 for citizens of Chile and Singapore, the E3 visa for Australian nationals, the TN for Canadian and Mexican, and the E2 investor visa, which can qualify for there are about 50 countries that qualify for this type of visa. So the H-1B1 specialty occupation. Now, the government about 10, 15 years ago carved out a special exemption from the H-1B visa cap for people who are citizens of Singapore or Chile. Don't know exactly what the reasoning was behind that or why they picked those specific countries, but that is basically the law. So basically there's an annual quota of 6,800 of these H-1B visas available, 1,400 from Chile and 5,400 from Singapore. It is very rare that someone uses this visa, so the visas are pretty much available. There's really no competition for these. So if you are a citizen of either one of these countries, then you can certainly consider applying if you meet the other requirements, being that you are in a specialty occupation and your employer agrees to the conditions of an H-1B visa. If you receive an H-1B1, you initially get 18-month period of employment. And unlike the H-1B visa, there is no limit on how long you can hold an H-1B1. So there's indefinite extensions. Spouses cannot work using the H-1B1, but of course they can reside in the U.S. with you. Spouses and children can. The other, similar to the H-1B visa, is the E3 Specialty Occupation Professional Visa for those who are citizens of Australia. So if you're a citizen of Australia, or if you have dual citizenship or multiple citizenships, and one of them is Australian citizenship, then you can qualify for the E3 Specialty Occupation Visa, which does have an annual quota as well of 10,500. However, again, it's very rarely used. We do not see many Australian citizens applying for this particular type of visa, but it is an option. It does require that the occupation be a specialty occupation, just like the H-1B visa. As I discussed, you have to have an occupation that requires at least a 4-year college degree or equivalent. It has a 2-year period of employment, but there's no limit on extension. So if you've got an E3 visa, you can actually continue forever on an E3 visa if you wanted to, but you would have to just apply for extensions every 2 years. And the other good thing about an E3 visa is that spouses can work with an E3 visa. Or if the principal person has the E3 visa, then their spouse can work as well in any occupation. The other visa, another country-specific visa that I wanted to discuss was the TN NAFTA professional visa. So this is for people who are citizens of Mexico or Canada. And so in order to qualify for this visa, your occupation itself has to be on what's called the occupations list. So you would have to look at the occupations list, which is provided at this regulation, and you can find it also online. And it's about 30 or so occupations, ranging from engineering, accounting, some healthcare professionals as well. So if you are fitting into one of the occupations on that list and you're a citizen of Canada or Mexico, then you can apply through your employer for a TN visa. The good thing about it is that there's no limit on the number of TN visas each year. There's no quota. It does allow 3-year periods of employment, which can be extended indefinitely. However, spouses cannot work on the spouses of the actual worker. TN worker cannot work. So spouses get what's called a TD visa. And with that TD visa, they can certainly live in the United States, but they cannot work. And the last country-specific visa program we'll talk about is the E2 visa program. Now, this is an investor program. It is not it's typically considered a worker program. So this is essentially for people who well, let me backtrack on that. It can be a worker visa for people who are not owners of an organization, but typically most people who apply for this are actually investing and owning a business in the U.S. And so they're making a substantial investment into a business, or they're buying or starting up a business, and they are a national of one of the 50 or so countries that are qualified for E2 visas. So for example, if you're a citizen of the UK, you can qualify. That is one of the countries on the list of E2 countries, and you decide that you want to buy a business in the US. The amount of or buy or start up a business, the amount of investment needed really varies depending on the type of business. If it's a service business, we've had people with as low as an investment of $10,000 qualify for this. But again, it just depends on the type of business. The more you can invest, the stronger chance you have of approval, and you must own at least 50% of the company that you are starting up or purchasing there. So if you qualify for the E2 visa, then you're able to now operate your own company, be self-employed, and hopefully grow your business and hire other people as well. how it comes in that if you cannot or do not want to be an investor in the E2 visa, however, you are of one of the nationalities that qualify for an E2 visa, and the company that wants to hire you is owned at least 50% or more by someone who is of your same nationality. So going back to the UK example, if you are a UK citizen and you want to work for a company that is owned by a company in the US that is owned by another UK citizen that owns 50% or more of the company, and you have the professional expertise that they need, then that company can also apply for your E2 visa. So you would be an E2 professional, personnel, or managerial worker of that E2 company itself. So that's an example of how someone can qualify as a worker and get an E2 visa. And if you get an E2 visa and you have a spouse, then your spouse can work as well. So let's now go on to other temporary visa options, which are rare, but it's some people may find this something to work with them to work if you don't have an get the H-1B visa. So the H-3 trainee. So this is a training visa. It is a sponsored visa by a company. So if you have a company that's offered you the H-1B position, but you couldn't get the cap, but now you want to consider maybe the H-3 trainee, which has no limit in terms of, or there's no quota for an H-3 trainee, but it has very specific requirements. One of the requirements is that it is a training visa. So it is for you to, similar to OPT, it's for you to get some experience and training in your particular field. And that training is not available in your home country. The position that they're offering you cannot really be a work situation where you're really doing a lot of work in order to for the operations of the company. It really has to be something and almost like a class. There has to be some classroom training. There has to be some things some particular training plan that shows that the company is really giving you a great training experience so that you can use that when you go back to your home country. So that's a 2-year maximum period of training or employment. There's no extensions, and spouses cannot work. Similarly, there's the J1 Exchange Visitor Trainee Program. Like the H3, it is a program where you're showing that there's going to be training for this particular employee. So you must have an approved program sponsor. And so the program sponsor is not necessarily your employer. It is a specific Department of State approved program that kind of coordinates these exchange visitor situations. So if you find an employer that agrees that they will want to keep you on for about 18 months at the most as part of a training program, and if you qualify as a trainee, meaning that you have a degree or a professional certificate, then you might want to consider this process as well. One thing you have to be careful of if you are considering a J1 exchange visitor program in order to remain in the U.S. and continue in some form of work and training is that there is with some J1 trainees, there could be a 2-year home residency requirement, which means that after your training is done or after you've completed the J1 training, you may be required to return home for 2 years before you'll be eligible for any other type of visa like an be eligible for an H-1B visa or even for green card. So you want to check what's called the country skills list to be sure that your country does not require your type of profession. Because if your country says, or if the country skills list says that typically we need this type of skill set, and you have that skill set, then you will be subject to the 2-year home residency requirement. Now you can often get a waiver of that, but it is an extra step that you have to take in order to next go on to any other type of visa or go on to permanent status. Okay, so the last area I think well, next to the last area we'll talk about quickly is the other temporary options. There's the L1 transferee and the O1 extraordinary ability visas. The L1 transferee visa is another employment-related visa that does require an employer, and it does require very specific situations. So basically, you would have to show that you have worked for the company that's going to hire you. You have worked for them at least 1 year abroad. So this is a company that has operations in the US and operations in at least one other country. If that's the case and you have worked for them outside the country for at least 1 year, then you could qualify to be transferred to the US in an L1 visa, transferee visa. It does require that you are either a high-level manager or you have a special knowledge about the operations of the company or their products, or something that is not easily found in the special knowledge that's not easily found in the US. If you can meet those qualifications, then you can get at least 5 to 7 years maximum time to be in the US on an L1 visa, and your spouse can work with the USC, can work on the your spouse who is an L2 visa holder can work with any position. And then this last section, and I'll talk about it, this last visa is the O1 Extraordinary Ability Visa. So this is a high-level visa. It does require an employer, but that employer can be actually a company you start up yourself can be the employer. So if you're able to start up a company with there's no minimum investment or anything like that required, or if you find a company that wants to hire you, that's already established, then you might qualify for an O1 visa. The advantage of the O1 visa is there's no limit on the numbers of O1 visas available each year. It does allow you for a 3-year initial period of employment, and extensions are unlimited, so you can hold O1 continuously, but you have to apply for extensions. But it's important to know that it is a high-level type of visa that requires quite a bit of evidence about your qualifications, because you have to prove that you have either sustained national or international recognition in your field. So, for example, if you are well, let's choose an example as a physician. If you're a physician and you have done certain things like written articles, you've won awards, you have spoken at conferences, you are serving as peer review. There's just a number of criteria. There's about 10 criteria that you have to show that you meet at least 3 out of those 10 criteria. If you can do that and show that you have considered to be risen to the top of your field, then an O1 visa could be an option for you. And also, you might want to consider if you are married to someone who has H-1B or an E-2 or an L1 or a J-1, any of the visas that we just discussed, you are, as I mentioned before, you could be eligible for work authorization based on their visa and you being a dependent on their visa. So if you have an H-4 visa, meaning that you're H-4 spouse, you're a spouse of an H-1B worker, and your spouse has applied for permanent status and received an I-140 petition approval, then you would be eligible for an H-4 EAD, which gives you work authorization for any occupation. If you are the spouse of an E-2 visa holder, you can work. An E-3 visa holder, you can work. If you are an L2, meaning you're a spouse of an L1 visa holder, you can work. And if you're a J2, meaning you're a spouse of a J1 visa holder, then you can work and receive an employment. Well, in some cases, actually for E2, E3, and L2, an EAD is not required, meaning that individual can actually work just by being an E2 status or E2 dependent status or E3 dependent status or L2 status. An EAD is no longer required for work authorization. However, an H4 or a J2 worker would need to apply for and receive an employment authorization document in order to work. So lastly, we'll talk, before we go to questions, we will talk about green card options. In some cases, a lot of times we get the question, well, do I have to have a particular visa? Do I have to have an H-1B visa before I can apply for the green card? And the answer is no. There's no particular type of visa, temporary visa or work visa that you have to have before you can actually apply for a green card. In most cases, if you have an employer to assist you or who is willing to apply for your green card, whether you're in O1 status, whether you're in J1 or H-1B or whatever status you are, or even if you're outside of the country, you can have an employer sponsor you for the green card. So the one way that happens is through the EB2, EB3 PERM labor certification process. This is a pretty complicated process, but it is totally doable. Many people go through this process. In fact, most people who are applying for green card through employment go through the EB2, EB3 PERM labor certification process. And the way that would work is that the employer would submit its application for you as the worker, and the employer must show that they've gone through a specified recruitment process where they have not been able to find a qualified U.S. citizen or permanent resident to meet who is qualified or interested in the position. The slide says physician, but it's not physician. It could be any occupation. So for any occupation, if the employer goes through the recruitment process and is unable to find qualified American citizens or permanent residents, then it can go to the next step of applying for labor certification. Some things that to be considered or to know about through this process is that the employer must be able to have sufficient income, business income, to show that they can pay your wage. So that can be a complicated process, but it's very important that if you are going to, or if you're working with an employer or plan to work with an employer who's going to sponsor you for this process, that they are able to show financially through their tax returns and other financial documents that they have sufficient business income to pay your salary, which is the minimum salary that's required by the government, or at least the salary that they're offering to you. You must be fully qualified for the position. So if the employer is recruiting for a specific position and they say that we can't find qualified people who are already citizens, well, of course, you must be fully qualified in order to be sponsored by this. So your qualifications must be there at the time of labor certification. And so this category applies again to any occupation, those who have advanced degrees, which is the EB2 category, advanced degree meaning master's degree or higher, those who are EB3 professionals, meaning you have bachelor's degree as part of your job requirement. And then you also have people who are unskilled or skilled workers, where they may not necessarily have degrees, but they have certain skill sets or have no skill sets, but they can still be sponsored through this process for permanent status. Now, that was a sponsored green card process. And we often have had people who, for example, have been on student status, were not able to capture one of the H-1B CAP visas, and actually had an employer who's willing to go ahead and apply for the EB2, EB3 PERM process. And so even without, again, having an H-1B visa, we're able to apply for that person. And in some cases, depending on their nationality, we're able to actually get the green card, or at least an EAD through the green card process, without ever having to be concerned with another type of temporary visa. So it's all about timing. It's very important to consider that. And that's why it's very important to talk with an attorney who can really lay out the plan and strategy if you're not able to get an H-1B visa or one of the other visas that we just discussed. The national interest waiver is another type of green card process. And the advantage to this one is that you do not necessarily have to have an employer sponsor. You can self-petition, meaning that you can apply on your own if you meet the qualifications. There are two types of national interest waiver applications or green card processes. One is general, what we call general, which means it applies to any profession. If you can show that your work, the work that you're doing, will somehow benefit the United States in either healthcare, education, competitiveness, industry competitiveness. It could be pretty much if you can make a case that your work is going to be something that the United States would be benefited by, then you could apply through as any type of professional. The most typical professionals are sort of researchers, but that's not the only limit. That's not the only type of profession that could be considered. The other type of national interest waiver is only specific to physicians. So if you're a physician who is willing to work for 5 years or agree to work for 5 years in an underserved area in any type of specialty, then a physician national interest waiver could be an option. And again, this is self-sponsored. Even though you are supposed to agree to work in a certain area, you don't necessarily have to have the actual employer sponsor you for this process. And then the other advantage to this is that it's often quicker to get into the national interest waiver process than it is for the PERM. You don't have to go through recruitment. Your employer does not have to be involved in really involved in the application itself. And in that way, if you are able to do self-sponsor, you might be able to get an employment authorization document while you're waiting for your green card to be approved. But ultimately, of course, this national interest waiver is a better route than even an H-1B visa. If you're able to qualify, you're able to get a green card. That is certainly a better advantage than the H-1B visa. But again, you have to meet the qualifications. Then the last category that we'll talk about where you can actually apply without an employer sponsorship for the green card is the EB-1A Extraordinary Ability Green Card. And that's where you must show that you, based on your background, your professional background, that you have had certain accomplishments that bring you to the level of having national or international recognition. I talked a little bit about the O1 visa. The criteria is very, very similar in that you have about 10 different criteria that the government asks that you prove at least 3 out of those 10 criteria. So if you can do that convincingly to the government, you can get an EB-1 Extraordinary Ability Green Card. And in most cases, it's fairly quick to get that type of green card. And again, you don't have to even be in the United States to qualify for that this type of green card. So before we go to questions, I just want to give you a brief timeline. When you're looking at these types of green card applications, you must be aware that you must be aware that there is an immigrant visa limit to green cards. So for any green card application that is applied through employment, depending on the category, there can develop a waiting list, what I call a waiting list, which basically means that the government says we have a limited number of green cards available each year. And depending on how many people are applying and what country they're from, we might not be able to give you a green card because you're going to have to be on that waiting list. And so it can be very significant. Some cases it can be 5-10 years if you're in the EB2 category from India, for example, or in some cases it could be a year or 2. Right now there is a current small backlog for certain categories for people from any country in the US. So it's a pretty detailed, but again, that's one of the things you have to consider when we're talking about applying for EB-1 or EB-2 national interest waiver, or even the PERM process. If we're looking for that way to get quickly to the green card, we have to consider whether or not the visa numbers are going to be available for you. If you're a physician who is working on a J-1 waiver through the interested government agency sponsorship, you will also have to know that regardless of whether you qualify through any of the processes that we discussed, you will not be able to get permanent residence until you've completed at least your 3 years of required service. But in most cases, if you are able to get into the green card process, you can get an employment authorization card that will allow you to work while you're waiting for the green card approval. And that wait for the employment authorization document, or EAD, can be anywhere from 6 to 12 months. The government now is trying to do things a lot faster in terms of EAD approvals, but we do have people who have been waiting longer, and the government has said that currently they can take up to 12 months or so to issue these types of work benefits. But in most cases, if you are not subject to the visa backlog, where you're in a category where there is no waiting list, you can get a green card within 1.5 to 3 years in most cases. Then keep in mind these things, this is as of today. Next year or the next month, it could be totally different in terms of these timeframes. So we're just giving you what we know as of this point. Okay, so now I'm going to go on and allow some questions. I know we have some questions here. And so again, to remind you, if you have a question, be sure to put your questions in the question and answer part of your platform, not the chat platform. I see that some people had some questions here, so let me see if I can pull up the questions in the Q&A. So I have a question here. The question is, what is the probability if you have an O1B visa to something more permanent? So that, in terms of stating probability, I mean, there's obviously a good chance if you've gotten an O1B visa, because an O1B visa qualifications or criteria is very similar to something like an EB1. So if you want to apply on your own without an employer sponsoring you for permanent status, then EB1As could be an option for you. Probability really just depends on a lot of things, so it's hard to say generally, but what you want to do is to be sure that you look at the criteria for EB1A, update and provide as much information for each criteria that you think you qualified for, including the criteria that you qualified through on the O1B category, and then basically apply. I mean, there is a good probability or possibility of being accepted, but it's a case-by-case basis. So, oh, I'm sorry, that's the wrong one. Okay, now I see a lot more questions popped up here. So let me just go through this. The next question I have is for F1 students. If you have worked full-time during the summer before graduating, does that time count towards your 12-month OPT time? So, well, you would have to have worked full-time, you would have to have either CPT or some other work authorization. So it's hard to say without knowing how you were able to work full-time before graduating. But let's say for CPT, for example, if you have a cumulative of 1 year of having CPT, then you normally are not qualified for OPT. If it's just a few months of working, then you may have deduction of that time that you worked from the OPT time. Okay, so hopefully that at least partially answered that question. Another question is, I have a question about an E1 visa, which I held in the past from a previous employer. If you have that kind of specific question, I do encourage you to contact us for a consultation so we can really get full details and be able to answer your question fully. Unfortunately, in this forum, I would not be able to answer that kind of specific question, but thank you so much for asking. The next question is, are you allowed to work to renew the visa while on OPT? Are you allowed to renew the visa while on OPT? Are there risks to going home to renew the visa? Okay, so I guess the question is, if you have an F1 OPT, which meaning that you've graduated from your program and are now working, but your visa is not approved, your visa has expired, It is possible to get a visa with the OPT by just because you have OPT, but it is risky. I mean, because again, the F1 visa is very much like a visitor visa. You do have to prove intent to return back to your home country after your OPT is completed. So it is going to be very subjectively evaluated by the consulate, but many people do get the extended visa. But my recommendation typically is not to travel until if you're on OPT. I would use a different or try to get another visa such as an H-1B or an O-1 or something that does not have that kind of non-immigrant intent requirement to get the visa. Next question is, I'm in Spain. I have a Spanish work permit and I'd like to move to US. What can I do? So again, that's a very specific question related to your own specific circumstance. I recommend definitely to reach out to us to schedule a consultation so we can get the full background for you and determine how you could qualify. Because again, as we went through all these different categories of visas, it is very specific to each person's individual background. So we would need to have a lot more information to determine whether you could qualify for any of those options or whether there are other options available to you. Another question is, would a dentist with a specialty qualify for the NIW and attain a green card? So yes, it's very possible. Now that would be for the general NIW, not the physician NIW. So for the general NIW, if you can show that you are doing work beyond your immediate work, if you are doing things that would be of national interest to the US. So for example, if you were doing research that is being published nationally or internationally, and you're going to continue doing that research in addition to your clinical practice, then yes, you could qualify for an NIW if the government is convinced that the additional professional activities that you're doing that have national reach would be of benefit to the US. But I would suggest to, again, consult with us to look at your CV and and discuss in length whether or not that would be an option for you. Next question is, how long does it take to switch from J2 to J2 from F1 to work under J2? How long does it take to get the EAD? Still up to 12 months. So the question is to switch from J to J2 from F1. That in itself would probably, if you're going to do it in the United States, then you're looking at least 6 months or more before you can get an approval of the I-539. There is no fast track premium processing of that. And after you get the J2, then applying for the EAD, it may still take another 3 to 6 months to get the J2 EAD. If you want to try to do that quicker, then you would have to go outside the country, get a J2 visa, come back with J2 status, and then apply for the EAD. Now, I'm not sure if going outside the country will be faster, depending on the embassy. Some embassies are quicker with their visa appointments. Some of them are still backlogged. So it depends on where you're from, but it may be faster to go to the embassy and get a J2 visa rather than applying for a change of status in the US from F1. Next question. This session was truly enlightening. Thank you. How soon can an O1 visa apply for a green card? Can I apply before my initial 36 months is over? Yes, there's no rule that states you have to wait any particular time frame in order to apply for permanent status. It just depends on whether you have sufficient evidence that would be strong enough to qualify. So again, you would want to meet with your attorney and discuss your qualifications and discuss your additional activities that you might have done, and get their opinion as to whether or not it's a good time to qualify. But there is no time limit on when you can qualify, when you can apply. Next question, can 2 different employers sponsor H-1B while filing for the lottery if they have 2 valid offer letters? And currently that is the case. Yes, you can have 2 different unrelated employers sponsor. the H-1B registration for the lottery. And that's probably one of the reasons why we had so many lottery registrations last year, because there are many people who are doing more than one employer or having more than one employer apply. Now that might change. They have had the government is looking into this, but currently I understand that it is still allowed for you to have more than one unrelated employer. The employers cannot be related to each other in any way to apply for the H-1B CAP registration. Okay. So I think that's all the questions that we have at this point. Thank you, everyone else, for your comments here. Appreciate your attendance here. This session has been recorded. One last thing I do want to remind everyone, as I probably have stated many times throughout the presentation, this is only for information and it's not legal advice. You should definitely, again, consult with an attorney to talk about your specific situation. Our information is here in case you don't have not had previous contact with us. You can reach out to us and schedule a consultation, either going to our website at badmuslaw.com or emailing me for a consultation appointment as well. So thank you again. I appreciate your attendance here, and apologies again for the technical difficulties and the late start. Have a great day.